Radloff Dairy versus Shade Tree, and MC of MC versus Shade Tree. Case numbers 185544, 5545, 5546CK. There are motions filed by Shade Tree relative for request for judgment notwithstanding the verdict and motion for new trial. We have issues regarding taxable cost and objections to entry of order. We'll begin first with the motions filed by Mr. Flory relative to judgment notwithstanding the verdict and new trial. Flory, you may proceed.
Thank you very much, Your Honor. Good morning. Adam Flory on behalf of the defendant, Shade Tree Dairy Supplies Incorporated. Your Honor, the court is intimately familiar with the facts of this matter. Obviously, the court presided over a 3-week jury trial, and therefore, Your Honor, I will not belabor the facts at this time. I also know that the court reviewed the briefs thoroughly. Your Honor, at this time, the motion that's presently in front of the court is a motion for judgment notwithstanding the verdict or the alternative for a new trial. Presently, Your Honor, there are 2 primary aspects that make up that motion. Your Honor, the first is that we respectfully assert that the court in error struck the notice of non-party fault that was filed in regard to naming IBA Incorporated as a non-party at fault. And Your Honor, the second issue was in regard to statements that were made during opposing counsel's rebuttal at the conclusion of the trial that were made in reference to evidence that had been excluded. And of course, those statements were made in reference to evidence, or rather those statements were made in front of the jury. Your Honor, taking those matters in reverse order first, in regard to the statements made by counsel, of course, we attached the relevant transcript of the rebuttal to the transcript. The court had an opportunity to review that, I know. At the time that those statements were made, well, first of all, Your Honor, just to orient our discussion here in regard to the statements, Mr. Concannon provided his closing statement and obviously provided advocacy during that statement. In response, Ms. Drillock in her rebuttal made a statement effectively trying to rehabilitate some of the criticism provided by Mr. Concannon as to some of the paltry damage proofs that were provided or not provided, in fact. And in that statement, Ms. Drillock stated words to the effect that she had attempted to introduce evidence, but we had objected to the evidence, and therefore, this evidence had been kept out by the court. At that time, Your Honor, both Mr. Concannon and I objected, and we took the matter up with the court. There was about a 5-minute bench conference. The court instructed the jury and informed them that that was not a proper statement to be made. However, Your Honor, despite the court's best efforts, and we thank the court for that, you could not unring the bell at that time. Your Honor, it was problematic from a couple of perspectives. Number one, it was especially problematic because it simply is black letter law. You cannot make reference to excluded evidence in front of the jury. So, Your Honor, not only for that, but it also it gave a terrible impression of the defense counsel and the defendant to the jury. It made it look like we were playing fast and loose and like we were trying to exclude evidence from the jury, which was not the case, of course. We were simply trying to ensure that the evidence that was admitted was under the constraints of the Michigan Rules of Evidence. And so it was just simply a doubly effective, improper statement made. And of course, a few hours after that, the jury came back with a significant verdict against the defendant, Your Honor. And so the problem at this point, Your Honor, is we can never know with specificity to what degree that improper statement affected the jury. What we know for certain is that it was made and it was entirely improper. There's no way to unring the bell. And then after that occurred, a significant verdict was returned. Your Honor, we cited applicable law in our brief, namely the People v. Goodwin case, 40 Mich. Ave. 709 at page 715. And Your Honor, in that case, the court lays out a paradigm for this court to follow to determine whether an additional remedy is appropriate in a circumstance such as this. Namely, Your Honor, in that case, counsel had made an improper statement to the jury, and the court had, in considering the remedy, the court considered, number one, whether the statement was brief or inadvertent. In this case, the statement was neither brief nor inadvertent, and it wasn't one word or anything like that. It was a colloquy on the part of opposing counsel that she engaged in, and certainly would have kept engaging in unless we would have objected, which we did. And it was not inadvertent, it was intentional, obviously. It wasn't like a slip up or she chose the wrong word. It was again, an intentional argument made to gain favor with the jury. The second point is whether it was made in the jury's presence. Of course, that answer is yes. The third point is whether it was made in an effort to restore credibility. That answer is yes. Your Honor, the court will recall that witness after witness after witness in this case punted to Mr. Dorr. Over and over again, the witnesses, including the parties, would say, I can't quantify damages. Over and over again, they would say that, and everyone put the emphasis on Mr. Dorr to quantify damages. So his testimony was critically important in that regard. There was not one single witness who stood up for damages on the plaintiff's part other than Mr. Dorr. And so again, his testimony was critically important in that regard. And I believe that we effectively had challenged Mr. Dorr's credibility and challenged the method that he used to quantify the alleged damages in this case. Mr. Kincannon had summarized that in closing, and again had engaged in what I think was very effective advocacy. And in an effort to ameliorate that and try to restore Mr. Dorr's credibility, Ms. Drillock made reference to evidence that was excluded, because she was trying to essentially excuse Mr. Dorr's paltry evidence that would stand up for the alleged damages in this case. And so again, it was certainly made in an effort to rehabilitate and restore Mr. Dorr's credibility. And lastly, Your Honor, the last point that's laid out in the Goodwin case, and this is at page 716, is whether the statement addresses a crucial aspect of the case. And again, Your Honor, that answer is in the affirmative for the very reasons I just said. It's not like we can say, okay, that was an improper statement, but take Mr. Dorr out of it. There were three other witnesses that the jury could have relied on. He was the only witness that the jury could rely on as far as damages go. And so it was absolutely crucial from that regard. It's an absolutely crucial element. We're talking about damages that obviously is entirely determinative of the award that the plaintiffs were going to receive, if any. And he was the only witness who could testify to that. So it simply could not have been more crucial. And so for each of those issues, it was neither brief nor inadvertent. It was made in the jury's presence. The statement was made in an effort to restore credibility and ameliorate an attack that we had made on Mr. Dorr's credibility because of the paltry evidence and paltry analysis that had been provided, and it addressed a crucial aspect of the case. Each of those statements is addressed in the affirmative, Your Honor. And again, Your Honor, I know that the court, I'm sure, would be loath to some degree to order a new trial because of all the effort that we all put in. The court put a tremendous amount of effort in. Mr. Locke did. We did as well, Mr. Kincannon and myself. But this was a completely avoidable circumstance. This did not need to happen. It was done purely in an effort to gain an advantage, and it was entirely improper to make reference to excluded evidence, as the court noted on the record, Your Honor. And again, you cannot unring that bell. You cannot unring that bell. You can't unring the bell of making reference to excluded evidence, and you can't unring the bell of an effort to make Mr. Kincannon and I look like we're playing fast and loose with the rules and we're trying to hide the ball on the jury. That was, in my view, highly detrimental to our credibility with the jury. And then later on, again, a few hours later, they returned an adverse verdict against us. And so for that reason, Your Honor, we believe that a judgment notwithstanding the verdict in our favor is appropriate, particularly because this was intentional error on the part of counsel. And the alternative, Your Honor, at a minimum, a new trial is appropriate because this intentional statement was made, and because it's impossible for us to say that that did not affect the jury's decision. Moving on, Your Honor, the second point, which is the first point in the brief, is the notice of non-party fault. Again, Your Honor, as the court is aware, we filed a notice of non-party fault relatively early in this case. That notice of non-party fault alleged fault against IBA Inc. under MCR 2.112K. IBA was the manufacturer of the TDIP, and we had alleged that they may be at fault due to some type of error in the manufacturing process, because the plaintiffs were making allegations related to that the TDIP was deleterious and that the mixing was also deleterious. Your Honor, I will largely rest on the written submission in support. I will simply say that MCR 2.112K makes reference to other actions. It's not limited to tort. It does make reference to other actions. We have cited a case in our brief which makes reference to the UCC and how we feel that that is analogous. And so, simply stated, Your Honor, the cases that we have found that we've provided to the court do not limit the non-party fault analysis to a tort case. It would be applicable to this case. And again, the other actions provision is quite broad. And so, with respect, Your Honor, we would respectfully assert that that notice of non-party fault should not have been stricken. And in terms of a remedy, Your Honor, the only remedy that's possible at this time would be either a JNOV or a new trial. Obviously, if the notice of non-party fault should have stood, there's no way to fix that now because IBA was not included on the verdict form for the jury to whom the jury could have allocated fault. So again, Your Honor, for the reasons in the brief, we respectfully assert that a JNOV is appropriate. And the alternative, if the court would disagree with that, then we would respectfully request a new trial so that the non-party at fault can stand. We can make arguments related to IBA, and the jury, if they determines it is appropriate, may allocate fault to IBA. And so with that, Your Honor, we would respectfully request the court enter an order awarding a judgment notwithstanding the verdict of a no cause of action as to each file and a judgment in the defendant Shade Tree's favor as to each file. Of course, I'm referencing the Paramount, Radloff, and MC files. And the alternative, Your Honor, we would respectfully request a new trial on each file. And thank the court for its time, Your Honor. I'd be happy to answer any questions.
No questions, Mr. Floyd.
Thank you.
Really.
I think I summed up in the brief the issues in response to Mr. Flory, but I just want to just briefly respond with regard to the inartful statement on 4 hours of sleep, I might add. But
Sorry, I didn't hear that.
I say on 4 hours of sleep, I might add, but in any event, the court will recall that prior to Mr. Dorr testifying that Dr. Michelle Borgstein testified at length regarding cull cows and dead cows. And in fact, that the defendant had the exhibits that are attached to the response in the record that specifically spelled out the dead cows and the cull cows. With regard to the statements, those were regarding Paramount only. And a review of the jury verdict demonstrates there was zero money given for cull cows, zero. The only money that was given was with regard to the dead cows. So with regard to that situation, this is a much ado about nothing, because even if there was something, the court corrected it. And as a result of the court's correction, the jury awarded zero on the cull cows, even though there was documentation from Dr. Michelle Borgstein, which was what I was trying to refer to, that there was part of the record that already had information that could drive their deliberation with regard to those issues. But I think that is disingenuous at best with regard to the situation under the circumstances. On top of it, MC of MC there's zero damages regarding that issue because, as the court knows, proper plaintiff wasn't included because of the situation with the personal versus the corporate. So again, much ado about nothing. And the other aspect of this, which is the Radloff, the information contained in Michelle Borick-Stein, Dr. Michelle Borick-Stein, and I would add, cross-examined extensively about that information, about whether the cows were replaced, et cetera, et cetera, et cetera, the court will recall. So with regard to that, I think it's very disingenuous. And ultimately, for a 3-week trial, Your Honor, this was probably the cleanest trial I've ever been a part of. And I have to say that I thought the court did a magnificent job in directing that. And to suggest that this should be a redo or a verdict on behalf of the defendant that didn't have any credible evidence before the jury, which was obviously demonstrated in the jury verdicts, is just not appropriate in the slightest. With regard to the non-party at fault, we've already argued this. I would indicate that some additional information that has been offered by defense counsel is with respect to the statutory site on a manufacturer. That has no relevance to this case now because Nybarger totally changed the lay of the land and changed how we do this. I think we may all agree that it's a little cumbersome with the way that the law reads as opposed to a products case, but it is what it is. They said we have to go through the UCC, and the UCC was a breach of warranty. There is no evidence on this record regarding IBA, and there probably never would have been because the defendant took the position that it took herein, in which didn't go so well. But ultimately, I think that the request of defendant should be denied in full, and if the court has any questions, I'm happy to respond to those.
I don't have any questions.
Thank you.
Mr. Flory, rebuttal, please.
Thank you, Your Honor. Just very briefly, Your Honor, as to the improper statement, Your Honor, it's not only the whole cow issue, Your Honor, it's the perception of the jury to defense counsel. Again, Mr. Elect intentionally made it look like we were trying to hide the ball, like we were trying to play fast and loose, when in reality, we were the ones sticking to the rules of evidence and seeking to have plaintiffs do the same. And so, Your Honor, you cannot reference excluded evidence to the jury. You cannot lay fault at the feet of an attorney for objecting under the grounds of evidence and then essentially implicitly lay fault at the court for keeping the evidence out and act like plaintiff's counsel were the ones trying to shed sunlight. So, Your Honor, again, the jury always wants to know more evidence. The jury always wants to have access to more facts, but we have rules of evidence for a reason to keep out evidence that for whatever reason is determined to be unreliable. That's what occurred in this case. And by making it appear like we were playing fast and loose or trying to hide the ball from the jury, we have no idea how that could have affected the jury's determination and what they thought of this case. Again, that's why you don't make statements like that, because it's like letting toothpaste out of the tube. Once it's out, there's no way to get it back in, and it's a poisonous effect on this case. And Your Honor, again, for those reasons, and Your Honor, Mr. Luck did not address the Goodwin analysis that was in our brief. It hits each one of those points. Your Honor, again, a remedy is needed on that issue. Lastly, Your Honor, as to the notice of non-party fault, I would simply state that I think it's, with respect to Mr. Elect, disingenuous to argue about what position we took, because the position we took was informed by that ruling. Yes, we took a certain position in our defense strategy based upon that ruling. If the ruling would have been different and if our notice of non-party fault would have stood, our position would have been different. And so, Your Honor, I don't think it's appropriate for that to inform the decision at all, because we would have made arguments related to IBA. We would have changed our defense strategy if that notice of non-party fault would have stood. And again, for the case law cited in our brief, we think that it should have stood for those reasons, Your Honor. Again, Your Honor, we would respectfully request a judgment in our favor, notwithstanding the verdict, or in the alternative, a new trial on each file. Thank you.
Thank you. Motion for judgment notwithstanding the verdict should only be granted where the evidence, when viewed in light most favorable to the non-moving party, fails to establish a claim as a matter of law. That's citing the Wilkinson case versus Lee at 463 Mich 388. It's a 2000 case. Basically, it comes down to this. If reasonable jurors could have honestly reached different conclusions, the jury verdict must stand. And party's motion for a JNOV is properly denied when judgment in that party's favor is not required as a matter of law based on the jury's finding of fact. That is found in the law offices of Jeffrey Sherbow, SHERBOWPC versus Feiger and Feiger, 326 Mishap 684. It's a 2019 case. Motion for new trial is as follows. A motion for new trial, bless you, may be granted to all or some of the parties on all or some of the issues whenever there are substantial rights materially affected for any of the following reasons, listing A through H of the court rule. And a party is not entitled to a new trial unless the party proves one of the grounds listed under MCR 2.611A1. So, looking at the issues before the court, moving in reverse order regarding the rebuttal argument that was made at the end of the jury trial before the jury deliberated. Clearly, there was an objection made. The objection was made before the jury. We did have a sidebar for a period of time. The court provided an instruction to the jury. And when we returned, and Mr. Flory is right, the court cannot unring the bell. That's impossible to do. But an instruction was provided to the jury. And frankly, from what the court looked at relative to the verdict in this case, the jury followed it. It wasn't a matter of this evidence appeared to be considered by the jury because a lot of zeros were provided relative to the relative to the evidence. But Dr. Borick-Stein had testified at length regarding, I believe, regarding damages as well, particularly in cross-examination, but also during her entire testimony. Now, the accountant, much less, and that was majority of that testimony was stricken from the record, but an instruction was provided. It appears that the jury followed the instruction. And looking at the light most favorable to the non-moving party, judgment with notwithstanding the verdict would not be appropriate. Now, I'm familiar with the case law cited by Mr. Flory relative to the statements and what was done and what was said, but a curative instruction was provided. Jury followed it as far as the court can see. Motion for judgment notwithstanding the verdict is denied. Regarding a new trial in this case is relative to that issue, that is. Relative to a new trial, the same opinion. There is no motion for new trial relative to the quote unquote excluded evidence considered. Now to the non-party fault issue. As to the non-party fault issue, obviously this is a UCC case. And again, Neibarger, if that's how you pronounce it, Neibarger is the law of the land. And looking at the evidence and looking at applying the law to it, I agree with Ms. Drillock relative to her analysis in this case. Judgment notwithstanding the verdict and new trial respectfully denied. Presented order, Mr. Floyd.
Thank you, Your Honor. Your Honor, would the court like for me to proceed on the taxable costs?
Please.
Your Honor, as the court will recall, we met here previously and we met in the jury room subsequent to the trial to discuss the judgment. Your Honor, at that time, Mr. Drillock and I came to an agreement on the jury's verdict was what it was. So those numbers stood, obviously. The interest calculation, Mr. Drillock and I came to an agreement on. At that time, Your Honor, a judgment was entered for those amounts on each file, the jury verdict and interest calculation. And Mr. Drillock essentially reserved for, further opportunity to make arguments on taxable costs. And that's what we're here for today. Originally, Mr. Drillock submitted a motion, or excuse me, a notice of presentment under a 7-day order, which essentially just submitted another order seeking taxable costs to be granted. We filed an objection. Then she submitted a motion which substantively contained the same information, and we filed a response to that. In regard to the taxable costs, Your Honor, we largely do not oppose the costs that were sought other than those relating to expert fees. In regard to the expert fees, Your Honor, the motion is opposed with regard to Dr. Bork-Stein, Dr. Erskine, and Mr. Dorr. If the court will just bear with me for one moment. Each witness, obviously, the plaintiff is only allowed to recover taxable costs with regard to each witness for very limited reasons. The issue, Your Honor, that we discussed in our brief, and that's laid out with Dr. Bork-Stein, is that the time is not broken down in any kind of discernible manner. And Your Honor, that must be done. That must be done. In my couple of years as a judicial law clerk in the circuit court for Saginaw, I would see these motions come all the time. And this was a frequent error that occurred and a reason for these costs not to be granted. And unfortunately, it's occurred multiple times. In this case, it is the plaintiff's obligation to establish an entitlement to these taxable costs. The plaintiff must do that. And so it's not good enough for the plaintiff to get kind of sort of close and kind of sort of establish it. If the plaintiff has not established that entitlement, the plaintiff's not entitled to the costs. It's that simple. And frankly, Your Honor, with the problem is in this case that everything was bolted together in terms of large entries. For example, with Dr. Bork-Stein, time was booked together for trial preparation and research. And there was a large number associated with that. Now, arguably, Dr. Bork-Stein is entitled to recover for trial preparation, or more aptly, plaintiffs are entitled to recover for her trial preparation and the fees that she billed, or at least a reasonable proportion thereof. But Your Honor, research is not recoverable, or at a minimum, we need to know what the research consisted of. Research on time educating counsel is not recoverable. Research on time researching our position or our strategy is not recoverable. And so again, that was the manner in which Dr. Bork-Stein chose to draft this invoice. The plaintiff's aware of the law. The plaintiff certainly had an opportunity to direct Dr. Bork-Stein on how the invoice needed to be drafted. And again, I would note that this is our second time here. We already came here, and this was the reason for the objection in the first place. And I said, this cannot be awarded in this manner because it's not laid out it's not laid out in what time is set aside for research, what time is set aside for preparation, what time is set aside for meeting with counsel. It's all just grouped together in one big number. And we're basically still here for that same reason, Your Honor. Again, the trial preparation and research is simply not in a discernible way. You can't put that down and say 18 and a half hours. Research is not recoverable. And because it's not broken down, the plaintiff therefore is not entitled to recovery. With regard to Dr. Erskine's time, it's the same thing, Your Honor. Dr. Erskine actually provided a pretty good breakdown, but the problem is with Dr. Erskine that the plaintiffs are seeking to recover for things that are plainly not recoverable. Dr. Erskine provided 1 hour for prep for testimony. He's entitled to recover that. He then provided 3.5 hours for his trial testimony. He's entitled to recover that. He provided for his lodging and his mileage. He's entitled to recover that. Everything else is outside of what is permitted to be recovered. And I think the plaintiffs are going to argue essentially that the other aspects of Dr. Erskine's time that's included in the ledger is part of the preparation. But Your Honor, that's plainly in contravention of Dr. Erskine's own invoice. Prep for trial testimony means prep for trial testimony. He told us how long he spent. He wrote 1 hour prep for trial testimony. Everything else was related to other things. And again, there's a number of other things that are possible. Educating plaintiff's counsel, researching the position of the defendants, substantiating his own position. None of that is recoverable. What is recoverable is trial preparation. And Dr. Erskine wrote that he spent 1 hour on that. So that's what the plaintiff is limited to. Again, this is a circumstance where the plaintiff had ample opportunity to work with Dr. Erskine and try to have him submit an invoice that accurately reflects his time. And I think we should take Dr. Erskine at his word. He said he spent 1 hour for trial preparation. That's what that the court should accept, and nothing else is recoverable there. Again, Mr. Doerr's invoice suffers from the same flaw as Dr. Borkstein. Underneath his prep portion, he wrote the numbers. He wrote a certain number of hours and then an hourly rate. It was different for each file, but that was the same manner for each file. The problem is we don't know what that was related to. Again, it's not broken down at all. It's just a big crooked number that he says he spent on this case. But again, was it related to trial preparation? Was it related to educating counsel? Was it related to researching defense position? Was it related to researching our experts? Was it related to researching to substantiate and buttress his own position? Who knows? He didn't include it. We can't, Your Honor, it's not fair to have us continually be forced to try to force them to stick to the requirements and then have them go back time after time and submit new invoices. This is their second opportunity. They've still not submitted an invoice that would entitle them to these large numbers that they're seeking. At this point, Your Honor, we would respectfully assert that the court should simply take what's been provided and make a ruling based upon that. And there's no way, Your Honor, respectfully, that these numbers can add up to what the plaintiffs are asking for, because it's not been provided by these alleged experts. So again, with Dr. Borkstein and Mr. Doerr, they've not broken it down at all and made clear at all what time is recoverable for preparation. That's their error. The burden is on them. With Dr. Erskine, he did provide an effective invoice and breakdown of what time was spent. And again, the court should take Dr. Erskine at his word and provide him with the 1 hour that was spent on trial preparation, his time for trial testimony, and his lodging and mileage. And Your Honor, we have submitted an appropriate order to that effect and attached it both to our objection and to our response. We would respectfully request that the court enter that order and have that be the final order for taxable costs.
Thank you.
Thank you, Your Honor.
Your Honor, obviously the court is aware this was a 3-week trial with a combined judgment of $2.27 million. So this was not a small deal. These experts were paramount with regard to the jury's understanding of this case and ultimate verdicts here. And with regard to the time and expertise spent, I find it interesting because opposing counsel complains about what the trial prep was for, but then when they break the trial prep down saying I had to read the depositions and do this, this, and this, and this, he complains that that's not trial prep. The trial prep specific 1 hour was the day before for Dr. Erskine, and all of the other stuff was the service dates are listed. So ultimately, I think that it's very complains on the one hand that it doesn't say what the trial prep is, but then when it does say the trial prep, he says, well, that's not trial prep. Well, that's not true. I told each one of these experts, I said, look, here's what is recoverable. So don't tell me anything other than that as it relates to what I have to have for the cost. Other stuff that is paid for is not relevant. And that's how this is. That they gave me what it was that they have said is the trial prep and the time. As it relates to,
Wait a second, that's a bit of a problem, because I'm not doubting you, counsel, but the issue I'm having is, I mean, how do you, it's not really broken down.
Well,
I mean, it sounds like it's being broken down based upon your statement saying this is what's taxable, do it. And they did it.
well,
I mean, no disrespect.
no. What I asked them to do was to break down the stuff that they did do in that matter. Understand that except for Dr. Erskine, who really was laid in the situation because, you know, he was originally part of the Michigan State Extension. And so he didn't do any work with regard to prep time or anything prior to all of the work regarding the prep time. I mean, so there was no billable hours for him prior to that, but Michelle Borg-Stein, there's billable hours that, you know, have been paid, depositions, blah, 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 through the course. And the same is true with Mr. Dorr. So when I get the bill, I say, look, you know, to the extent that this is trial prep, then, you know, tell me what it is that you've done. And that's what I got back. You know, and then it wasn't satisfactory, and I asked them to break it down further. Now, I do agree on Dr. Michelle Borg-Stein. She says research, and I told her, I said, I didn't think that is probably recoverable, but if that's what you did, then that's what you got to put down, and that's what she did. So she has, I think, 2 or 3 hours for research, and the balance of it is, as I understand it, and what she's told me, is the reading the depths and getting ready for the trial testimony. So that's all I can say, Your Honor, is that I told them to tell me what it was that they did. And, you know, she also told me something else. And I said, that's fine, because, you know, that's what you did. I don't think it's recoverable, but put it on. And she did. So except for that, I think that all of this, I mean, Mr. Dorr specified the trial time and the trial prep, and I think it's all recoverable. All I can say, Your Honor.
Any other arguments?
Just very briefly, Your Honor. Again, with each of these folks, we're left to guess at what their time included. Dr. Borg-Stein grouped her time together as trial preparation and research. We can't guess at what aspect of that was trial prep and what aspect was research. Your Honor, the burden is on these folks to establish entitlement to recoverable expenses, costs. And if they don't do that, Your Honor, it's got to be zero. And so, again, with respect to Dr. Borg-Stein and Mr. Dorr, it's simply not broken down in a form that would provide them with an opportunity to recover it. So, Your Honor, again, even though it may seem harsh, that's the appropriate determination because they've not established an entitlement to it. And again, with respect to Dr. Erskine, we should believe what he said. He said he spent 1 hour on trial prep. That's what he wrote. So he's entitled to recover that, Your Honor, plus his trial testimony and lodging and mileage. We respectfully request the court enter the order attached to our response. Thank you.
Court will issue a written opinion.
I just want to make certain. Did you get the updated one from Dr. Michelle Borg-Stein? Because she does break out the research.
I'm sure I did, Your Honor. I will rest on
And
our written submission.
and as well as the other, but I just want to make sure you got that.
I'm sure I did.
Oh, okay.
Court will issue a written opinion.
Thank you, Your
Thank
Honor.
you, Your Honor.